Chapter 3 Void and Voidable Marriages Article 80. The following marriages shall be void from the beginning. 1. Those contracted under the ages of 16 and 14 years by the male and female respectively, even with the consent of the parents. 2. Those solemnized by any person not legally authorized to perform marriages. 3. Those solemnized without a marriage license, save marriages of exceptional character. 4. Bigamous or polygamous marriages not falling under Article 83. Number 2. 5. Incestuous marriages mentioned in Article 81. 6. Those where one or both contracting parties have been found guilty of the killing of the spouse of either of them. 7. Those between stepbrothers and stepsisters and other marriages specified in Article 82. N. Article 81. Marriages between the following are incestuous and void from their performance, whether the relationship between the parties be legitimate or illegitimate. 1. Between ascendants and descendants of any degree. 2. Between brothers and sisters, whether of the full or half-blood. 3. Between collateral relatives by blood within the fourth civil degree. 28a. Article 82. The following marriages shall also be void from the beginning. 1. Between stepfathers and stepdaughters and stepmothers and stepsons. 2. Between the adopting father or mother and the adopted, between the latter and the surviving spouse of the former, and between the former and the surviving spouse of the latter. 3. Between the legitimate children of the adopter and the adopted. 28a. Article 83. Any marriage subsequently contracted by any person during the lifetime of the first spouse of such person with any person other than such first spouse shall be illegal and void from its performance, unless 1. The first marriage was annulled or dissolved, or 2. The first spouse had been absent for 7 consecutive years at the time of the second marriage without the spouse present having news of the absentee being alive, or if the absentee, though he has been absent for less than 7 years, is generally considered as dead and believed to be so by the spouse present at the time of contracting such subsequent marriage, or if the absentee is presumed dead according to Articles 390 and 391. The marriage so contracted shall be valid in any of the 3 cases until declared null and void by a competent court. 29a. Article 84. No marriage license shall be issued to a widow till after 300 days following the death of her husband, unless in the meantime she has given birth to a child. N. Article 85. A marriage may be annulled for any of the following causes, existing at the time of the marriage. 1. That the party in whose behalf it is sought to have the marriage annulled was between the ages of 16 and 20 years, if male, or between the ages of 14 and 18 years, if female, and the marriage was solemnized without the consent of the parent, guardian, or person having authority over the party, unless after attaining the ages of 20 or 18 years, as the case may be. Such party freely cohabited with the other and both lived together as husband and wife. 2. In a subsequent marriage under Article 83, Number 2, that the former husband or wife believed to be dead was in fact living and the marriage with such former husband or wife was then in force. 3. That either party was of unsound mind, unless such party, after coming to reason, freely cohabited with the other as husband or wife. 4. That the consent of either party was obtained by fraud, unless such party afterwards, with full knowledge of the facts constituting the fraud, freely cohabited with the other as her husband or his wife, as the case may be. 5. That the consent of either party was obtained by force or intimidation, unless the violence or threat having disappeared, such party afterwards freely cohabited with the other as her husband or his wife, as the case may be. 6. That either party was, at the time of marriage, physically incapable of entering into the married state, and such incapacity continues, and appears to be incurable. 30a. Article 86. Any of the following circumstances shall constitute fraud referred to in Number 4 of the preceding article. 1. Misrepresentation as to the identity of one of the contracting parties. 2. Non-disclosure of the previous conviction of the other party of a crime involving moral turpitude, and the penalty imposed was imprisonment for 2 years or more. 3. Concealment by the wife of the fact that at the time of the marriage, she was pregnant by a man other than her husband. No other misrepresentation or deceit as to character, rank, fortune or chastity shall constitute such fraud as will give grounds for action for the annulment of marriage. N. Article 87. The action for annulment of marriage must be commenced by the parties and within the periods as follows. 1. For causes mentioned in Number 1 of Article 85, by the party whose parent or guardian did not give his or her consent, within 4 years after attaining the age of 20 or 18 years, as the case may be, or by the parent or guardian or person having legal charge, at any time before such party has arrived at the age of 20 or 18 years, 2, for causes mentioned in number 2 of Article 85, by the spouse who has been absent, during his or her lifetime, or by either spouse of the subsequent marriage during the lifetime of the other, 3, for causes mentioned in number 3 of Article 85, by the same spouse, who had no knowledge of the other's insanity, or by any relative or guardian of the party of unsound mind, at any time before the death of either party, 4, for causes mentioned in number 4, by the injured party, within 4 years after the discovery of the fraud, 5. For causes mentioned in number 5, by the injured party, within 4 years from the time the force or intimidation ceased, 6, for causes mentioned in number 6, by the injured party, within 8 years after the marriage. 31a, Article 88. No judgment annulling a marriage shall be promulgated upon a stipulation of facts or by confession of judgment. In case of non-appearance of the defendant, the provisions of Article 101, paragraph 2, shall be observed. N. Article 89. Children conceived or born of marriages which are void from the beginning shall have the same status, rights, and obligations as acknowledged natural children, and are called natural children by legal fiction. Children conceived of voidable marriages before the decree of annulment shall be considered as legitimate, and children conceived thereafter shall have the same status, rights, and obligations as acknowledged natural children, and are also called natural children by legal fiction. N. Article 90. When a marriage is annulled, the court shall award the custody of the children as it may deem best, and make provision for their education and support. Attorney's fees and expenses incurred in the litigation shall be charged to the conjugal partnership property, unless the action fails. 33a, Article 91. Damages may be awarded in the following cases when the marriage is judicially annulled or declared void from the beginning. 1. If there has been fraud, force, or intimidation in obtaining the consent of one of the contracting parties. 2. If either party was, at the time of the marriage, physically incapable of entering into the married state, and the other party was unaware thereof. 3. If the person solemnizing the marriage was not legally authorized to perform marriages, and that fact was known to one of the contracting parties, but he or she concealed it from the other. 4. If a bigamous or polygamous marriage was celebrated, and the impediment was concealed from the plaintiff by the party disqualified. 5. If in an incestuous marriage, or a marriage between a stepbrother and a stepsister or other marriage prohibited by Article 82, the relationship was known to only one of the contracting parties but was not disclosed to the other. 6. If one party was insane and the other was aware thereof at the time of the marriage. N. Chapter 4 Authority to Solemnize Marriages Article 92. Every priest, or minister, or rabbi authorized by his denomination, church, sect, or religion to solemnize marriage shall send to the proper government office a sworn statement setting forth his full name and domicile, and that he is authorized by his denomination, church, sect, or religion to solemnize marriage, attaching to said statement a certified copy of his appointment. The director of the proper government office, upon receiving such sworn statement containing the information required, and being satisfied that the denomination, church, sect, or religion of the applicant operates in the Philippines, shall record the name of such priest or minister in a suitable register and issue to him an authorization to solemnize marriage. Said priest or minister or rabbi shall be obliged to exhibit his authorization to the contracting parties, to their parents, grandparents, guardians, or persons in charge demanding the same. No priest or minister not having the required authorization may solemnize marriage. 34a, Article 93. Freedom of religion shall be observed by public officials in the issuance of authorization to solemnize marriages. Consequently, no public official shall attempt to inquire into the truth or validity of any religious doctrine held by the applicant or by his church. N. Article 94. The public official in charge of registration of priests and ministers shall cancel the authorization issued to a bishop, head, priest, rabbi, pastor, or minister of the gospel of any denomination, church, sect, or religion, on his own initiative or at the request of any interested party, upon showing that the church, sect, or religion whose ministers have been authorized to solemnize marriage is no longer in operation. The cancellation of the authorization granted to a priest, pastor, or minister shall likewise be ordered upon the request of the bishop, head, or lawful authorities of the denomination, church, sect or religion to which he belongs. 35a. Article 95. The public official in charge of registration of priests and ministers, with the approval of the proper head of department, is hereby authorized to prepare the necessary forms and to promulgate regulations for the purpose of enforcing the provisions of this title. Said official may also by regulations fix and collect fees for the authorization of priests and ministers to solemnize marriages. 36a. Article 96. The existing laws which punish acts or omissions concerning the marriage license, solemnization of marriage, authority to solemnize marriages, and other acts or omissions relative to the celebration of marriage shall remain and continue to be in force. N. Title IV Legal Separation Article 97. A petition for legal separation may be filed, 1. For adultery on the part of the wife and for concubinage on the part of the husband as defined in the Penal Code, or, 2. An attempt by one spouse against the life of the other. N. Article 98. In every case the court must take steps, before granting the legal separation, toward the reconciliation of the spouses, and must be fully satisfied that such reconciliation is highly improbable. N. Article 99. No person shall be entitled to a legal separation who has not resided in the Philippines for 1 year prior to the filing of the petition, unless the cause for the legal separation has taken place within the territory of this Republic. Sector 2A, Act No. 2710. Article 100. The legal separation may be claimed only by the innocent spouse, provided there has been no condonation of or consent to the adultery or concubinage. Where both spouses are offenders, a legal separation cannot be claimed by either of them. Collusion between the parties to obtain legal separation shall cause the dismissal of the petition. 3A, Act No. 2710, Article 101. No decree of legal separation shall be promulgated upon a stipulation of facts or by confession of judgment. In case of non-appearance of the defendant, the court shall order the prosecuting attorney to inquire whether or not a collusion between the parties exists. If there is no collusion, the prosecuting attorney shall intervene for the state in order to take care that the evidence for the plaintiff is not fabricated. N. Article 102. An action for legal separation cannot be filed except within 1 year from and after the date on which the plaintiff became cognizant of the cause and within 5 years from and after the date when such cause occurred. 4A, Act 2710, Article 103. An action for legal separation shall in no case be tried before 6 months shall have elapsed since the filing of the petition. 5A, Act 2710, Article 104. After the filing of the petition for legal separation, the spouses shall be entitled to live separately from each other and manage their respective property. The husband shall continue to manage the conjugal partnership property, but if the court deems it proper, it may appoint another to manage said property, in which case the administrator shall have the same rights and duties as a guardian and shall not be allowed to dispose of the income or of the capital except in accordance with the orders of the court. 6. Act 2710, Article 105. During the pendency of legal separation proceedings, the court shall make provision for the care of the minor children in accordance with the circumstances and may order the conjugal partnership property or the income therefrom to be set aside for their support, and in default thereof said minor children shall be cared for in conformity with the provisions of this code, but the court shall abstain from making any order in this respect in case the parents have by mutual agreement made provision for the care of said minor children, and these are, in the judgment of the court, well cared for. 7A, Act 2710, Article 106. The decree of legal separation shall have the following effects. 1. The spouses shall be entitled to live separately from each other, but marriage bonds shall not be severed. 2. The conjugal partnership of gains or the absolute conjugal community of property shall be dissolved and liquidated, but the offending spouse shall have no right to any share of the profits earned by the partnership or community, without prejudice to the provisions of Article 176. 3. The custody of the minor children shall be awarded to the innocent spouse, unless otherwise directed by the court in the interest of said minors, for whom said court may appoint a guardian. 4. the offending spouse shall be disqualified from inheriting from the innocent spouse by intestate succession. Moreover, provisions in favor of the offending spouse made in the will of the innocent one shall be revoked by operation of law. N. Article 107. The innocent spouse, after a decree of legal separation has been granted, may revoke the donations by reason of marriage made by him or by her to the offending spouse. Alienation and mortgages made before the notation of the complaint for revocation in the registry of property shall be valid. This action lapses after 4 years following the date the decree became final. N. Article 108. Reconciliation stops the proceedings for legal separation and rescinds the decree of legal separation already rendered. The revival of the conjugal partnership of gains or of the absolute conjugal community of property shall be governed by Article 195. 10A Act 2710, Title V Rights and Obligations between husband and wife. Article 109. The husband and wife are obliged to live together, observe mutual respect and fidelity, and render mutual help and support. 56A, Article 110. The husband shall fix the residence of the family. But the court may exempt the wife from living with the husband if he should live abroad unless in the service of the Republic. 58A, Article 111. The husband is responsible for the support of the wife and the rest of the family. These expenses shall be met first from the conjugal property, then from the husband's capital, and lastly from the wife's peripheral property. In case there is a separation of property, by stipulation in the marriage settlements, the husband and wife shall contribute proportionately to the family expenses. N. Article 112. The husband is the administrator of the conjugal property, unless there is a stipulation in the marriage settlements conferring the administration upon the wife. She may also administer the conjugal partnership in other cases specified in this code. N. Article 113. The husband must be joined in all suits by or against the wife, except 1. When they are judicially separated, 2. If they have in fact been separated for at least 1 year, 3. When there is a separation of property agreed upon in the marriage settlements, 4. If the administration of all the property in the marriage has been transferred to her, in accordance with Articles 196 and 197, 5. When the litigation is between the husband and wife, 6. If the suit concerns her peripheral property. 7. When the action is upon the civil liability arising from a criminal offense. 8. If the litigation is incidental to the profession, occupation, or business in which she is engaged. 9. In any civil action referred to in Articles 25 to 35, and 10. In an action upon a quasi-delict. In the cases mentioned in NOS 7 to 10, the husband must be joined as a party defendant if the third paragraph of Article 163 is applicable. N. Article 114. The wife cannot, without the husband's consent, acquire any property by gratuitous title, except from her ascendants, descendants, parents-in-law, and collateral relatives within the 4th degree. N. Article 115. The wife manages the affairs of the household. She may purchase things necessary for the support of the family, and the conjugal partnership shall be bound thereby. She may borrow money for this purpose, if the husband fails to deliver the proper sum. The purchase of jewelry and precious objects is voidable, unless the transaction has been expressly or tacitly approved by the husband, or unless the price paid is from her peripheral property. 6-A, Article 116. When one of the spouses neglects his or her duties to the conjugal union or brings danger, dishonor, or material injury upon the other, the injured party may apply to the court for relief. The court may counsel the offender to comply with his or her duties, and take such measures as may be proper. N. Article 117. The wife may exercise any profession or occupation or engage in business. However, the husband may object, provided 1. His income is sufficient for the family, according to its social standing, and 2. His opposition is founded on serious and valid grounds. In case of disagreement on this question, the parents and grandparents as well as the family council, if any, shall be consulted. If no agreement is still arrived at, the court will decide whatever may be proper and in the best interest of the family. N. Title 6 Property Relations between Husband and Wife Chapter 1 General Provisions Article 118. The property relations between husband and wife shall be governed in the following order: 1. By contract executed before the marriage, 2. By the provisions of this code, and 3. By custom. 1315a, Article 119. The future spouses may in the marriage settlements agree upon absolute or relative community of property, or upon complete separation of property, or upon any other regime. In the absence of marriage settlements, or when the same are void, the system of relative community or conjugal partnership of gains as established in this code, shall govern the property relations between husband and wife. N. Article 120. A minor who according to law may contract marriage, may also execute his or her marriage settlements, but they shall be valid only if the persons designated by law to give consent to the marriage of the minor take part in the antenuptial agreement. In the absence of the parents or of a guardian, the consent to the marriage settlements will be given by the Family Council. 1318a, Article 121. In order that any modification in the marriage settlements may be valid, it must be made before the celebration of the marriage, subject to the provisions of Art. 191, 1319a, Article 122. The marriage settlements and any modification thereof shall be governed by the statute of frauds, and executed before the celebration of the marriage. They shall not prejudice third persons unless they are recorded in the Registry of Property. 1321a, Article 123. For the validity of marriage settlements executed by any person upon whom a sentence of civil interdiction has been pronounced, the presence and participation of the guardian shall be indispensable, who for this purpose shall be designated by a competent court, in accordance with the provisions of the Rules of Court. 1323a, Article 124. If the marriage is between a citizen of the Philippines and a foreigner, whether celebrated in the Philippines or abroad, the following rules shall prevail. 1. If the husband is a citizen of the Philippines while the wife is a foreigner, the provisions of this code shall govern their relations. 2. If the husband is a foreigner and the wife is a citizen of the Philippines, the laws of the husband's country shall be followed, without prejudice to the provisions of this code with regard to immovable property. 1325a, Article 125. Everything stipulated in the settlements or contracts referred to in the preceding articles in consideration of a future marriage shall be rendered void and without effect whatever, if the marriage should not take place. However, those stipulations that do not depend upon the celebration of the marriage shall be valid. 1326a, Chapter 2 Donations by reason of marriage Article 126. Donations by reasons of marriage are those which are made before its celebration, in consideration of the same and in favor of one or both of the future spouses. 1327, Article 127. These donations are governed by the rules on ordinary donations established in Title III of Book 3, except as to their form which shall be regulated by the Statute of Frauds, and insofar as they are not modified by the following articles. 1328a, Article 128. Minors may make and receive donations in their antenuptial contract, provided they are authorized by the persons who are to give their consent to the marriage of said minors. 1329a, Article 129. Express acceptance is not necessary for the validity of these donations. 1330, Article 130. The future spouses may give each other in their marriage settlements as much as 1/5 of their present property, and with respect to their future property, only in the event of death, to the extent laid down by the provisions of this code referring to testamentary succession. 1331a, Article 131. The donor by reason of marriage shall release the property donated from mortgages and all other encumbrances upon the same, with the exception of easements, unless in the marriage settlements or in the contracts the contrary has been stipulated. 1332a, Article 132. A donation by reason of marriage is not revocable, save in the following cases: 1. If it is conditional and the condition is not complied with; 2. If the marriage is not celebrated; 3. When the marriage takes place without the consent of the parents or guardian, as required by law; 4. When the marriage is annulled, and the donee acted in bad faith; 5. Upon legal separation, the donee being the guilty spouse; 6. when the donee has committed an act of ingratitude as specified by the provisions of this Code on Donations in General. 13338, Article 133. Every donation between the spouses during the marriage shall be void. This prohibition does not apply when the donation takes effect after the death of the donor. Neither does this prohibition apply to moderate gifts which the spouses may give each other on the occasion of any family rejoicing. 13348, Article 134. Donations during the marriage by one of the spouses to the children whom the other spouse had by another marriage, or to persons of whom the other spouse is a presumptive heir at the time of the donation are voidable, at the instance of the donor's heirs after his death. 13358, Chapter 3 Peripheral Property Article 135. All property brought by the wife to the marriage, as well as all property she acquires during the marriage, in accordance with Article 148, is peripheral. 13818, Article 136. The wife retains the ownership of the peripheral property. 1382, Article 137. The wife shall have the administration of the peripheral property, unless she delivers the same to the husband by means of a public instrument empowering him to administer it. In this case, the public instrument shall be recorded in the Registry of Property. As for the movables, the husband shall give adequate security. 13848, Article 138. The fruits of the peripheral property form part of the assets of the conjugal partnership, and shall be subject to the payment of the expenses of the marriage. The property itself shall also be subject to the daily expenses of the family, if the property of the conjugal partnership and the husband's capital are not sufficient therefor. 13858, Article 139. The personal obligations of the husband cannot be enforced against the fruits of the peripheral property, unless it be proved that they redounded to the benefit of the family. 1386, Article 140. A married woman of age may mortgage, encumber, alienate or otherwise dispose of her peripheral property, without the permission of the husband, and appear alone in court to litigate with regard to the same. N. Article 141. The alienation of any peripheral property administered by the husband gives a right to the wife to require the constitution of a mortgage or any other security for the amount of the price which the husband may have received.